obviously any of you can answer these, but I just want to get clarification on what the measure actually does. So does SJR 33 repeal Measure 36, was passed in 2004?
Chair Lieber, Vice Chair Knopp, Measure 30.
Introduce yourself for the
I'm
record.
sorry, yes. Dexter Johnson, Legislative Counsel. And I'm joined by my colleagues, Senior Deputy Legislative Counsel Lorianne Sills and Senior Deputy Legislative Counsel Dan Gilbert.
And before you go on, I will say that we do have on the previous panel, if they need to jump in to answer a question, I want to allow that because they've got some attorneys over there that know some stuff.
Sure. Vice Chair Knopp.
It's really hard to hear you facing that direction.
I will try and speak up. I don't believe these actually amplify. They might, but
They don't.
I don't think so. Vice Chair Knopp, your question was whether this repealed Measure 36, which is the Oregon policy of marriage being one man and one woman.
Yes.
Yes, it does.
Okay. What individuals are not currently protected by the 14th Amendment of the U.S. Constitution that would receive new protection from SJR 33?
Chair Lieber, Vice Chair Knopp, that is a very open-ended question, and I am unable to give you a definitive answer.
I'll follow up to that.
Follow up.
So, I mean, would women and girls of any age seeking an abortion be getting a new protection, a new right under SJR 33?
Chair Lieber, Vice Chair Knopp, SJR 33 is an amendment to the existing Oregon Equal Rights Amendment, which previous testimony revealed is itself a relatively new amendment for which there has not been any definitive court interpretation of what standards would be applied to legal questions like you're asking. So we can't answer with some certainty.
Okay, are you done?
Well, I'm going to actually ask Lorianne if you have additional guidance there.
Lorianne Sills with Legislative Counsel.
Speak up as much as you can.
Okay, I have a small voice, so I will try. Senator Knopp, would you mind restating your question so I make sure I'm answering the right thing?
Sure, Lori. So what individuals are not currently protected by the 14th Amendment of the U.S. Constitution that would receive new protection from SJR 33?
I think that you had a follow-up question to that, which was about women and...
So when Dexter wasn't sure, I asked him if girls or women of any age seeking an abortion would receive essentially a new right under this SJR 33.
So as Dexter mentioned, we can't say anything with certainty right now because, one, the Oregon Supreme Court hasn't had the opportunity to look at any cases coming under the Oregon Equal Rights Act since it was enacted in 2014. So we're not sure what standard of review they would use. Also, the court's interpretation of the amendments to the Oregon Equal Rights Act by SJR 33 would look at materials that we don't have yet. They're still being created, including through this process. So it's difficult right now while that is being developed to predict how the court would interpret the amendments to the Oregon Equal Rights Amendment. However, that said, when the U.S. Supreme Court handed down its decision in Dobbs last year that overturned Roe v. Wade, and under Roe v. Wade, that was interpreted to provide women and minor pregnant people who could become pregnant, regardless of their age, with a constitutional right to access abortion services. When that went away with Dobbs, there was no longer that constitutional right unless it exists in some other constitutional provision that has not been determined yet. So the provisions of SJR 33 amend the Oregon Equal Rights Act to say that you can't have any law that discriminates on the basis of pregnancy outcomes, and related health decisions. If the Oregon Supreme Court was interpreted that to apply to a right to abortion, access abortion, then yes, I believe that that would probably apply to people who can become pregnant of any age. However, that would also depend on the voters' intent if they were to adopt this. And the scope of that right for minors would also depend on the voter intent when it is adopted.
Okay. May I continue, please?
Yes.
If SJR 33 became part of Oregon's constitution, would the legislature ever be able to pass a law that only allows biological women to participate in women's sports?
Chair Lieber, Vice Chair Knopp, I'm going to again return to where I started, which is that there is uncertainty until the courts establish what a standard of review would be. Let's take a hypothetical example, however. If there was a standard of strict scrutiny, which might be the case, then if the Legislative Assembly passed a measure that only permitted individuals whose biological sex at birth was women, is that correct with your question, Senator?
Say again?
If the Legislative Assembly passed a measure limiting participation in sports to
Biological women.
to biologically, well, okay. Then, under a strict scrutiny standard, there would be the court would consider the, I'm blanking on it. Yes, it must be narrowly, the reason for the legislature acting must be a compelling reason, and the restriction must be narrowly tailored to achieve whatever that compelling reason was. So with this hypothetical, I wouldn't know what the Legislative Assembly's purpose was in actually taking that action, but that would be the action the court would go through.
Okay. How about this one? So if SJR 33 became part of Oregon's constitution, can schools legally separate any sport, bathroom, or locker room facility by gender?
Senator,
Chair.
I think you're asking about how constitutional law is actually done in the courts, and I don't know if it would be helpful. Each of these questions are specific, and I think that they're going to have the same answer. Maybe if you'd like Dexter to explain to you sort of how the constitutional law would work in this case, but
Well-
we're not going to have a specific yes or no on it because it's the way constitutional law works. It has to be.
No, I understand, but it sounded like the proponents, these are some of the things that they're trying to avoid, and I'm just asking, is this measure, this constitutional measure, actually preventing those from occurring? So if we
Okay.
don't know the answer to that, it seems like the measure should be written in a way that it is clear,
Okay.
right? How about this one? Would SJR 33 require a Catholic-owned hospital or insurance provider to pay for abortion, perform abortions, or pay for a sex change surgery or perform sex change surgery?
Well, the measure, Chair Lieber, Vice Chair Knopp, the measure applies to government action. So that wouldn't apply to a Catholic hospital.